Hi, welcome to this 45th session on the insolvency and bankruptcy code, under which liquidation is the precise topic that we are talking. And today we will cover preferential transactions as part of liquidation process. But before that, let us quickly do the recap of what we have done in the previous session. In the previous session, we have covered section 41 of the IBC, which talks about determination of valuation of claim, how the liquidator will determine the value of the claim. After that, we have discussed under section 42 that if the resolution professional or liquidator rejects the claim, there can be an appeal that can vest with the adjudicatory authority. And after that, we proceeded to section 52, where secured creditor in liquidation proceedings, what is his position? We've discussed that very clearly. Then section 53 is what we have covered, which is nothing but the waterfall mechanism, or how distribution of assets is done after the liquidation or under CIRP. Then the last topic that we have discussed in the previous session was dissolution of a corporate debtor. That I said is a end stage of the liquidation, after which the company will come to a complete termination. So this is quick recap of what we have done yesterday. Today we are going to start preferential transactions. But before I take you to preferential transactions and show you what is section 43 speaking about, it is very important for us to understand the background of the entire concept. There are 4 transactions which we call as avoidance transactions under IBC. What do you mean by avoidance transactions? This would mean that those transactions which fall under the 4 categories which I am going to discuss now, those 4 transactions can be avoided if a liquidator or a resolution professional so thinks on an application to adjudicatory authority. These 4 transactions which have already occurred will now be avoided. That means the transaction will be reversed. Why is this done? This is done because those 4 transactions which have been done in the past have been either done with a negative intent of actually affecting the claimants at the time of CIRP or liquidation, or which are done to give a specific advantage to a certain party which is maybe related to corporate debtor. Therefore, the moment a liquidator identifies this kind of a transaction, he will intimate the adjudicatory authority that there are certain transactions which have happened. These are not good for the corporate debtor, and the adjudicatory authority will actually reverse these transactions. Then that's why they are called as avoidance transactions. Now, what are those transactions? Number 1 is called as a preferential transaction, where because of the transaction done, a certain party receives a preference in time of liquidation or CIRP, which it would have otherwise not received, which is not a healthy transaction for other claimants under liquidation or CIRP. Hence, this transaction should be avoided. Second transaction is called as undervalued transactions. What do you mean by that? Where the company should have received a reasonable amount of money for a certain transaction, it had done these transactions for a lesser value, received less money, ultimately affecting the claims of the claimants in liquidation or the CIRP. Hence, such transaction should be avoided. Now, the third transaction is called as the fraudulent transaction, which is done to specifically defraud the creditors. Whatever sums that they were due to get, those sums will not come to them because of a transaction that has occurred between CD and some other party. Hence, that is also not a healthy transaction for the claimants. Hence, that should be actually avoided. And the last one is called as extortionate transaction, where the company has paid reasonably more money than what it should have paid to the third party. Such transactions are not healthy. So these are the 4 headings. Out of them, the first heading is what we are covering, which is called as a preferential transaction. This provision ensures that related parties do not use any insider information of the corporate debtor to make unlawful gains for themselves. The effect of that section is that it invalidates all such preferential transactions which are entered into by the corporate debtor within a relevant time. So, these transactions have been entered into with a certain intent based on certain information which is already available to the CD, and those transactions are unhealthy for other claimants and hence they will be cancelled now if it is proved in the court of adjudicatory authority. What is a preferential transaction? If you want to understand this, we have to go to section 43, subsection 1, which clearly explains what is a preferential transaction. Where the liquidator or the resolution professional, as the case may be, is of the opinion that the corporate debtor has at a relevant time given a preference in such transactions and in such manner as laid down in subsection 2 of the same section, then he shall apply to the adjudicating authority for avoidance of such preferential transaction and for one or more orders which can be delivered under section 44. So this is basically a preferential transaction. I am going to give you an example shortly as to how do you understand the preferential transaction. Section 43(2) talks about how a transaction will be deemed to be a preferential transaction. A corporate debtor shall be deemed to have given a preference if there are two transactions. Number one, if there is a transfer of property or an interest thereof of the CD for benefit of a creditor or a surety or a guarantor for or on account of any antecedent financial debt or operational debt or the liabilities owed by the CD. That means there were certain debts that have already been created between the CD and the creditor, and now the CD gets into some arrangement with the creditor to give him a special position within the company so that at the time of liquidation or CIRP, this creditor will be certainly in a better position than what he was before. Okay. Then, second part of the transaction says, the transfer under clause A has the effect of putting such creditor or a surety or a guarantor in a beneficial position than it would have been in the event of a distribution of assets under section 53. So very clear, if I as a creditor have not entered into this transaction with the CD, then I would have only received a smaller amount under section 53 at the time of liquidation or CIRP. But now that I have entered into this transaction, I will be definitely in a better position. That is part B of section 43 subsection 2. Now I'll give you a clear example. How do you understand what is a preferential transaction under section 43? Mr. Neil and Mr. Kamal. These are just random examples. There is no relation to any actual or real company outside. So Mr. Neil and Mr. Kamal are directors of Neil Kamal Import and Export Private Limited. In the year 2020, the company borrowed 5 crores from Mr. Raj Kamal, who is brother of Mr. Kamal, the director of the company, without giving any security. This transaction is very important. So the company borrowed money from brother of a director without giving any security. The brother trusted the company and its prospects and gave loan of 5 crores, which is a very huge amount. However, in December 2024, the company's office building situated at Nariman Point, Mumbai, is given as a security. So, in case the money is not repaid to Mr. Raj Kamal, then Mr. Rajkamal can recover the money from the security created on that property. This is the whole idea. The property is worth 25 crores. Look at now the whole transaction, what is happening. Mr. Rajkamal lent only 5 crores, but what he is now getting is a 25 crore worth of a property as a security for his loan. If the security was not given, then Mr. Rajkamal would have received only 1 crore under CIRP or liquidation. Now, in this scenario, the CIRP had already began against the company. Hence, when the resolution professional is appointed to take care of the entire process, the first thing that he will do is he will look into this transaction and report to adjudicating authority and say that the company has created a certain security for an antecedent financial transaction to put that certain creditor in a preferential position, and hence he will ask the adjudicating authority to set aside this transaction, and hence Mr. Rajkamal will be treated as if he had no security whatsoever from Nilkamal company. I'm sure the transaction is pretty clear to you now. We will try to understand what are the consequences with the help of case laws. However, Section 43 also gives exceptions where maybe a certain transaction will not be dealt as a preferential transaction and hence it will not be set aside. What are those transactions where it will not be dealt as a preferential transaction? Number one, transfer made in the ordinary course of the business or financial affairs of the corporate debtor or the transferee. Now, if I am a real estate company, I am into the business of buying and selling properties. I might sell a certain property to a certain party depending on the market scenario at a price which is less or more. But it is my ordinary course of business. I have not done any favor to any creditor. Hence, maybe such transaction will not be termed as preferential transaction. I'm reading the part B now. Any transfer creating a security interest in property acquired by the corporate debtor to the extent that such security interest secures value and was given at the time of or after the signing of a security agreement that contains a description of such property as security interest and was used by a corporate debtor to acquire such property. That means if I am acquiring a certain property and I am borrowing money and I am creating a security interest on such property by way of an agreement, then such creation of security interest will not be termed as a preferential transaction. And the last exception, the line is, such transfer was registered with an information utility on or before 30 days after the corporate debtor received possession of such property. Now, as far as part B is concerned, there are two conditions. One is, you should have acquired this property with the funds given by the lender and created a security interest on the same asset by way of a agreement. And two, you should have registered this agreement with a information utility center within 30 days from occupation or possession of that certain property. If these two conditions are met, then your transaction may not be termed as a preferential transaction. Last point, the fact that a transfer is made in pursuance of order of a court does not preclude such transfer to be deemed as giving preference by the corporate debtor. Remember, as far as a normal court is concerned, like a high court or a district court, these courts may not examine your transaction from the perspective of an avoidance transaction. If there is a dispute between two parties, the court may order transfer of property to one party without actually going into the details of avoidance transactions. But just because there is an order of the court, you cannot say that this is not an avoidance transaction. In spite of being an order of the court, the transaction may still be termed as an avoidance transaction and may be cancelled by the adjudicatory authority if it is so proved by the resolution professional or liquidator with substantial evidence. Okay, so going forward, presumption of a preferential transaction. When can the courts or the resolution professional presume that a certain transaction was entered only to put a certain party in a preferential position? If it is proved that the person receiving benefits from the CD had sufficient information about the commencement of CIRP or is a related party of the CD, the transaction during the relevant period will be presumed to be a preferential transaction. So very importantly, we are trying to understand the intent of the parties. Intent of the parties is simple, that I as a creditor, I know that the company is in a bad shape, it is going into insolvency, and before it goes into insolvency, I as creditor would want to secure my position, and hence I put pressure on the company, and company actually does some transaction to put me in a preferential position, and hence these transactions can be avoided. Conditions for presumption, we are now covering part B of those conditions. The presumption applies if the person had sufficient information about the initiation of CIRP or the person is a related party of the CD. Only in these cases we will presume that there is a preference given to a certain party. The last point is very important. Who has the burden of proof? That means, should the liquidator or the resolution professional prove that this is a preference transaction, or is it the responsibility of the other party to prove that it is not a preferential transaction? Hence, let's look at this paragraph. It will be presumed that the interest was acquired or the benefit was received not in good faith unless the contrary can be shown by the other person receiving the benefit. Now remember, if I am the creditor, I received the benefit, it is my duty or obligation to prove that I have not entered into any preferential transaction and the transaction was in good faith and it's a bona fide transaction. Unless and until I prove that, there is a presumption and belief that the transaction was actually a preferential transaction. Now, there's a case law. This will make it clear for you as to what is a preferential transaction. Anuj Jain is a IRP for JP Infratech Limited versus Axis Bank is a case. Now, this is under section 43 of the code and adjudicatory authority is none other than the Honorable Supreme Court of India. Now, the facts of the case. Number one, JP Infratech Limited is a subsidiary of JAL, which is another JP Group company. JAL borrowed loans from various bankers and secured those loans with the assets, which is normal practice. JIL has created mortgage on its own properties to secure the loans borrowed by the holding company on a subsequent date. Now remember, the moment I am saying that the loan had occurred on a certain date and the security is created at a later date, we are referring to an antecedent transaction as is mentioned under section 43. The moment there is an antecedent transaction which is being covered or protected now with the help of a certain transaction, there is a very decent chance of it becoming a preferential transaction, right? So JIL wanted to secure the loan borrowed by JAL and had given its own properties as securities for the lenders. If allowed, or if really it goes well, This will impact the other lenders and also Home Buyers Association, because JP Infratech Limited was building houses and there were several projects under development. Because this company is now under resolution process, several projects of residential houses which had welfare societies were really affected by CIRP. Now they will come and say that they would want these assets to be with them so that they can actually do housing building activity. But if these properties are now mortgaged with the creditors of the holding company, then the housing societies cannot get any grip on those assets and they'll be badly affected. So this is why now the discussion as to whether this is a preferential transaction, yes or no. Fact number 5. At that time when the CIRP commenced, the RP made an application to NCLT stating that I have witnessed certain preferential transactions and I want them to be cancelled. However, the good news is NCLT understood what RP wants to say and it has cancelled all the preferential transactions. Right? Now when it has cancelled all the preferential transactions, for RP it is a good relief. But there will be a party which is obviously affected or aggrieved by this order. Who's that? All the creditors who got the mortgage of properties of JIL will now be aggrieved by the order of the NCLT. Therefore, they moved an appeal to NCLAT. That's point number 6, the fact 6 if you see. It's an application to NCLAT. Now, what did NCLAT do? NCLAT actually favored the creditors and said there is no preferential transaction and had completely taken opposite view of what NCLT had taken. Now, see, if you are looking practically, these are, this will make you nervous as a lawyer or an advocate or a corporate professional. One learned honorable adjudicatory authority goes in favor of a RP or a liquidator and calls a certain transaction preferential. On an appeal, the appellate tribunal takes a complete 360-degree turn back and actually favors the appellants, saying that there is no preferential transaction. This is the uncertainty in the legal system. But anyway, we are not going to debate on those. So when NCLAT had said there is no preferential transaction, again it is now RP who's affected by the order of the NCLAT. Now therefore, there will be an appeal to the Supreme Court by the RP and his accompanying parties for the benefit of liquidation and CIRP again to take an order for avoidance of these preferential transactions. What happened after that? There are two issues that are cropping up. Issue number 1, whether the transactions should be avoided, treating them as a preferential transaction, whether the mortgagees who got this preferential treatment shall be dealt as financial creditor, or shall we completely call them as illegal claims and treat them as unsecured creditor. Two very, very critical issues that are cropped up from this case, and let's see what happened in the term at the time of conclusion. The Supreme Court, very rightly so, had set aside the orders of NCLAT. It went back and appreciated the orders of NCLT. It upheld its orders. It declared the transaction as preferential and hence had once for all concluded that these transactions be avoided. If the transactions are avoided, there are two ways of looking at it. One, whatever is a preferential position that is set aside and he will now be a normal creditor, or sometimes what we do is we will completely make them not a financial creditor and call them as a unsecured creditor who will make the claims under section 53 of the act after all the preferential creditors get their money. Now very interestingly, if there is a preferential transaction, when an application is made by RP or a liquidator, what is the order that will be passed by NCLT or adjudicating authority, and what kind of orders can it pass, and what will be the impact of such orders on the CIRP or liquidation? Number one, a property that is part of a preferential transaction will now vest in the CD. That can be order number one. That means property had gone out of the grip of the CD for a preferential transaction. Hence, it cannot be part of the liquidation estate. Now what adjudicatory authority is saying is, it had to be now reversed, and then the property will now be part of liquidation estate, which is a great benefit to the claimants under liquidation or CIRP. Second type of an order that adjudicatory authority can pass is sale proceeds, whatever have been received by the corporate debtor or transferor, that sale proceeds will now be part of the liquidation estate and hence will be equally shared by the parties as per section 53. Next one is, if there is any security that is created, such security interest will be discharged and hence the secured property will be free in the hands of corporate debtor. Fourth one is, if there are any sums received by any third parties which is not CD, those third parties should return the sums to the liquidation estate. Like a commission agent might have made a lot of commission, they will be asked to return that commission so that now it becomes part of the liquidation estate. If a person is discharged of liability preferentially, remember there are two types of transactions. It is not always creditor who gets a preferential treatment. There can also be a debtor of the company who gets a preferential treatment. How? If I have borrowed loan from a CD and the CD had said that you pay me 5% of your loan and I'll completely relinquish your liability, that is also a preferential position. Therefore, in that case, if I am discharged of my liability, adjudicatory authority will now make me liable again. So these are 5 types of orders here that NCLT may pass. Apart from that, it may also provide security or create any charge on a property which is to be coming to CD. Then 7th point is, claims as financial creditor or operational creditor to be proved in liquidation or CIRP. If there is a suspicion that there is a preferential transaction, then adjudicatory authority will say that I am setting aside your preference, you prove your claim just like any other creditor and take your money from the RP or liquidator. This is one of the greatest orders that it can pass. And the last one is release or discharge of any financial or operational debt to be proved in liquidation or CIRP. Once it is discharged, now there is no more claim that those parties can make. So these are few orders which can be made by adjudicatory authority in times where it sees a preferential transaction. However, remember, any person who had acted in good faith, such person's transaction cannot be affected by the order of the NCLT, where I am reading the paragraph now. An order by NCLT under section 44 will not affect any interest in property that was acquired from a person other than the corporate debtor in good faith and for value. This protection extends to any interest derived from such property if it is coming from a third party. Now I think we have a lot more clarity on what preferential transactions are. Just before I conclude and summarize, I would always suggest that please, after listening to these sessions, always just go back to Bare Act and try to make your own reading and make your own points as to what are the critical areas that you would want to examine under IBC. After that, We are also going to read regulations sometimes so that you will understand how to relate regulation plus the provision under IBC. And keep on revising from time to time. It helps you retain the subject far better. And as I said in the previous session, please also keep on, tracking the real life cases that are happening. IVBI portal gives you substantial information on real time cases that are ongoing currently. Please track them. Okay, so to conclude the session, summary, we have learned what is a preferential transaction under section 43. In what circumstances do we deem that there is a preference, who has the burden of proof, and lastly, in such cases where it is established that there is a preferential transaction, what kind of orders can be passed by the adjudicatory authority under section 44 of the Act, and we have covered a case law, that is Anuj Jain, in the case of a JP Infratech Limited's case to understand preferential transaction. So this brings us to the end of 45th session, and we will meet in 46th session. Thank you.